Hello friends, I am continuing important questions on Bharatiya Nyaya Sanhita BNS. Question number 3. Explain the shift from punishment to justice as the soul of the BNS. BNS की आत्मा के रूप में दंड से न्याय की ओर हुए बदलाव की व्याख्या कीजिए. Answer is the shift from punishment to justice lies at the philosophical core of the Bharatiya Nyaya Sanhita 2023. This reform replaces the colonial era IPC, which was primarily designed for retribution and deterrence, with a legal framework centered on fairness, rehabilitation, and restorative justice. Under the IPC of 1860, the criminal justice system primarily sought to punish wrongdoers to maintain colonial law and order. The focus was on retribution, public deterrence, and the authority of the state. By contrast, the Bharatiya Nyaya Sanhita seeks to deliver justice, aiming to balance the rights of victims, accused persons, and society. It reflects Indian constitutional principles and values like compassion, rehabilitation, and dignity. Now, key aspects of the shift. What are the changes been made? Introduction of restorative and rehabilitative justice. The BNS introduces community service as a new form of punishment. Section 4, marking a significant shift towards reform rather than retribution. This provision applies to petty offences, allowing offenders to reintegrate into society through service rather than incarceration. Second is victim-centric approach. The VNS places the victim at the core of justice delivery. Compensation provisions and protective mechanisms aim to restore victims' dignity, not merely punish offenders. This approach contrasts with the IPC, which focused more on the offender's culpability than on victim rehabilitation. Third is decriminalization of outdated offences. The awareness removes colonial and moralistic offences such as sedition and replaces them with acts against the sovereignty and integrity of India, reflecting a justice-based approach rooted in constitutional value rather than state control. Emphasis on forensic and evidence-based justice, moving beyond arbitrary punitive action. BNS and its companion law, the Bharatiya Nagarik Suraksha Sanhita, stress scientific investigation, forensic evidence collections. Reformation of sentencing philosophy. The BNS distinguishes between heinous, organized, and petty crimes, ensuring proportionality in sentencing. Minor offenders are rehabilitated through reform, while severe offenders remain subject to deterrent penalties. This proportional approach embodies justice, not mere vengeance. Illustrative example in this respect, under the IPC, a petty theft would simply result in imprisonment. Under the BNS, the same act may lead to community service, accompanied by victim restitution. Similarly, the old offense of sedition is replaced by a narrowly defined clause protecting national integrity, avoiding misuse against dissenters, and aligning with a democratic justice. Thus, the BNS marks India's evolution from a colonial punitive code to a homegrown, justice-oriented framework. Now, question 4. Examine the defense of unsoundness of mind under Section 22 of the BNS. How does it align with principles of criminal responsibility? Section 22 of the Bharatiya Nyaya Sanhita embodies the defense of unsoundness of mind, continuing the long-established doctrine of criminal irresponsibility rooted in Section 84 of IPC. It exempts from criminal liability those who, at the time of committing the act, are incapable of knowing the nature of their act or realizing that it is wrong or contrary to law due to mental unsoundness. Section 22 of the BNS provides, nothing is an offence which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act or that the act is either wrong or contrary to law. This legal test focuses narrowly on the state of mind of the accused at the moment of the offence, not before or after the act. Now, essential conditions for the defence. Following are the essential conditions for the defense. Number one, the accused must have been suffering from unsoundness of mind when the act was committed, not merely before or after. Incapacity to understand the nature of the act. The person must have been incapable of understanding what they were doing or its consequences. For instance, if a person kills someone but cannot comprehend that the act is homicide, the defense may apply. Incapacity to know the act is wrong or illegal. The person must have been unable to distinguish between right and wrong or to recognize the illegality of the act. Alignment with principle of criminal responsibility. The doctrine in section 22 directly reflects the Macnaghten Rules 1843, a cornerstone of modern criminal law, which emphasizes that liability requires both a guilty mind, mens rea, and a wrongful actus reus. If an accused lacks mens rea due to insanity, criminal responsibility cannot arise. Mens rea and moral culpability. Criminal acts require intention, knowledge, or recklessness. A person of unsound mind lacks these mental elements, making punishment inconsistent with moral blameworthiness. Presumption of sanity and burden of proof. While every person is presumed sane under law, the burden lies on the accused to prove unsoundness under Section 105 of Indian Evidence Act 1872 on a balance of probabilities, not beyond reasonable doubt. Legal insanity versus medical insanity. Section 22 upholds the distinction between legal insanity. Legal insanity means inability to understand the nature or wrongness of the act. And medical insanity means mental illness diagnosed by doctors. Only the former qualifies for exoneration. Judicial interpretation and case law. Dayabhai Chhaganbhai Thakkar versus State of Gujarat, Air 1964, the Supreme Court held that insanity must be proven to have existed at the time of act, completely impairing cognitive faculties. Now question 5. Discuss the nature and kinds of punishment provided under the Bharatiya Nyaya Sanhita. What changes have been introduced? Answer is the Bharatiya Nyaya Sanhita introduced 6 principal kinds of punishment for crime offences. Number 1. Addition of community service. The most noteworthy change in BNS is the formal introduction of community service as a punishment. This reflects a shift from pure retribution to rehabilitation, allowing minor offenders to contribute positively to society instead of facing incarceration. Emphasis on rehabilitation. The code allows for more nuanced sentencing, recognizing that not all crimes demand strict imprisonment. For example, theft of property valued under 5,000 or attempting suicide with obstruction of public duties may now result in community service, highlighting consideration for mental health. Enhancement punishment for serious crime. BNS has made penalties for certain offences more severe compared to IPC, particularly grave crimes like trafficking, murder, organized crime, and offence against women and children. Mandatory filing culpable homicide. For example, in case of culpable homicide not amounting to murder, BNS mandates a minimum sentence of 5 years and compulsory fine. Separate sentencing guidelines for specific professions. In cases involving death by negligence, BNS distinguishes punishment if committed by a medical practitioner as opposed to others, with the reduced sentence for doctors is maximum 2 years and for others it is up to 5 years. Moving towards fairer treatment. Removal and streamlining of colonial provisions. Offences such as sedition and Section 377 IPC are omitted, and provisions have been consolidated for modern legal needs to reduce ambiguity. Now, question 6. Rarest of the rare criteria is a legal principle developed by the Supreme Court of India, which applies in the case of giving death penalty. Explain its importance, essential elements, and cite its application in a case law. The rarest of the rare doctrine means the death penalty in India is awarded only for the most brutal and exceptional crimes that shock society's conscience, where no punishment less than death is deemed adequate. It was established by the Supreme Court in Bachan Singh versus State of Punjab in 1980 and guides courts to consider the brutality of the crime, motive, impact on society, and possibility of reform on the accused, making sure capital punishment is truly rare. The essential elements considered by courts are the manner of crime, extreme brutality, cruelty or atrocity in execution, motive, depravity, perversion or highly antisocial intent, impact on society. Crime shocks the collective conscience of the community, impossibility of reform, no chance of rehabilitation or reformation for the offender, proportionality, the punishment must fit the magnitude and heinousness of the crime. The possibility of alternative punishment must be unquestionably foreclosed. Thanks for watching this video, friends. Do subscribe my channel.